Sometimes the biggest fights start over the smallest things. So what happens when a simple, everyday request for some paperwork gets met with, well, complete silence? For one homeowner, it blew up into a full-blown legal battle with her HOA. We're going to break down exactly how a few unanswered emails ended up in a courtroom. Just look at this sentence. It's pulled directly from the legal petition. And man, it just tells a story of pure frustration, doesn't it? I mean, can you imagine? You send a request, you follow up again and again, and you just get nothing. That's really the heart of our story today, that feeling of being totally ignored and what one homeowner finally decided to do about it. All right, so let's set the scene. On one side, we have Annette Cohen. She's a homeowner in a condo association out in Sun City West, Arizona. And on the other side? Well, that's her Homeowners Association, the CBS 136 HOA.
So what was this huge knockdown, drag-out fight all about? Was it a massive fine, a big rule violation? Nope. All Miss Cohen wanted were the sign-in sheets from 2 recent meetings. That's it. A totally basic piece of association paperwork. Seems simple enough, right?
Now, you might think this is just about common courtesy or, good customer service, but it's actually a lot more than that. As Ms. Cohen was well aware, there's a specific state law in Arizona that lays out exactly how an HOA is supposed to handle requests just like hers. And that really gets to the core of this whole case. What does Arizona law actually require from an HOA in a situation like this? What are they legally obligated to do when a member asks to see the records? Well, the law is surprisingly crystal clear on this. The Arizona statute says all records have to be made reasonably available, and it gives the HOA a very firm deadline, 10 business days. It doesn't say whenever you get around to it or when it's convenient. Nope, 10 business days. 10, that's the magic number here. It's not a suggestion, it's not a guideline, it's a legal requirement. And as we're about to see, it's the rule that the CBS 136 HOA just blew right past. So after getting absolutely nowhere with her emails, Annette Cohen basically decided she was out of options. She took the next big step and filed a formal petition with the Arizona Department of Real Estate. And just like that, her simple request officially became a legal complaint. And this timeline, wow, it really paints a picture of that mounting frustration. So she asks for the January sheets on January 10th. She doesn't get them until February 15th. That's over a month later. And that was after scheduled appointments got canceled. So then the whole cycle starts over again for the February sheets. She asks on February 19th, follows up multiple times, and by March 5th, still nothing. Crickets. So just 4 days after that final attempt, she'd had enough and filed the official complaint. Okay, so the case goes to a hearing on June 6th. Now, the HOA had already admitted they missed the 10-day deadline, so that wasn't really up for debate. The real question for the judge was, why? Was this intentional? Were they just ignoring her on purpose? Or was it just an unfortunate mistake, an administrative screw-up? Now, before we jump into the arguments, there's a quick legal thing we gotta understand. It's called preponderance of the evidence. Sounds super complicated, but all it really means is that Miss Cohen had the burden of proof. She just had to convince the judge that her side of the story was more likely true than not true. That's it. So at the hearing, you get these 2 totally different stories. On one hand, Ms. Cohen is arguing that the HOA's delays were absolutely intentional. I mean, her proof was pretty simple. They could have just emailed the documents in a second, but they didn't, so she demanded a penalty. On the other side, the HOA is basically saying it was all a big misunderstanding. They blamed a really messy management transition and said it just took a little longer than expected to track down the paperwork. All right, so you've heard both sides. The arguments are on the table. How did the administrative law judge rule? Who came out on top? What were the consequences? And what was the logic behind it all? The judge's order came down in 3 main parts. First, Annette Cohen was officially declared the winner, the prevailing party. That's a big deal. Second, the HOA had to pay back her $500 filing fee. And third, the judge formally ordered the HOA to follow that 10-day law from now on. So a pretty clear win for the homeowner, right? Well, not so fast. Because here's where the story takes a really interesting turn. Even though the judge found that the HOA did, in fact, break the law, she decided not to impose any other fines or penalties on them. At all. So Ms. Cohen got her filing fee back, and that was it. So why no penalty? Well, basically, the judge bought the HOA's excuse. She came to the conclusion that the delay wasn't malicious. It was just a result of incompetence during that messy management change.
And in her view, that circumstance, as she put it, meant a financial penalty just wasn't appropriate here.
So think about that for a second. After months of sending emails, going through the whole process of filing a formal petition, and sitting through a legal hearing, the grand total Annette Cohen got was her own $500 filing fee back. She won on principle for sure, but the HOA faced literally zero punishment for breaking a state law.
And that really brings us to the big question at the end of all this. I mean, she was proven right. She absolutely stood up for her rights as a homeowner, and she won. But when you think about all the time and all the effort it took just to get her own money back, was it worth it? Put yourself in her shoes for a second. Would you have gone to all that trouble to hold your HOA accountable over a simple piece of paper? It's that classic question of principle versus practicality, and honestly, there's no easy answer.